number 18, the people of the state of New York versus Jose Velez.
Good afternoon, Your Honors. My name is Yvonne Shivers. I represent Jose Velez. I'd like to request 2 minutes for rebuttal.
You may.
Thank you. Much of what I would cover has been covered by the first case, but I wanted to point out something about the proposition that the electropherogram is the equivalent of the raw data for any purpose counsel could use it for. One thing defense counsel specifically stated in his motion was that given its scale, it would be impossible to tell from the printed electropherogram whether the information that ought to have been labeled an allele was not labeled an allele. That's one more clear indication that getting the electropherogram would not be enough for an expert to evaluate whether or not the findings were mistaken, incorrect, or there were significant problems with it.
Counsel, if you were to get the raw data, let's say it's now, and you got the raw data, would that cure any confrontation violation under Sean John? Because Sean John says, you need to have an analyst up there who's comparing the final product to the raw data. So if the defense has the raw data and can cross on it, does that cure the confrontation problem?
No, not necessarily. I mean, in this case, the criminalist who testified had not examined the raw data. And if you look at her testimony, which is something that...
Is that because if she had, then the expert could cross-examine her on, maybe if now you have dueling experts, so you've got a credibility issue, right?
Right.
And right?
Yes, and it's important for the defense expert, to be able to not only have their own expert perhaps present it, but also to cross-examine the person who examined the raw data. In this case, it's clear, just jumping over to the Sean John issue, that the analyst did not examine the raw data. In fact, her testimony was a lot like the criminalist in John. The criminalist in John said that she looked to see everything that had been done, reviewed the results of the editing to make sure she agreed that the artifact should have been taken out. The criminalist here testified that she reviewed each and every portion of the testing that occurred in this case. That's basically what she said. Now, the people contend that what this means, based on a case they cited called Corey, is that she sort of redid everything. But in fact, that wasn't her testimony. That was the testimony of the criminalist in Corey. The criminalist in Corey specifically said, I redid it, the testing of the raw data. And that's completely distinguishable from this case in which the analyst did not do that. So on that basis alone, the defendant was deprived of his confrontation rights.
Didn't she also testify that with respect to the defendant's oral swab, she developed a full DNA profile from the sample? Isn't that the record at 151? And if so, what does that tell us?
She developed a full DNA profile from the sample? I believe she testified that someone did, but that she personally did not.
Okay, I may have misread the record. That's why I'm asking.
Yeah, I think the record clearly shows that she did not take part in any of the tests or any of the editing of the raw data with respect to the DNA report that was generated from the defendant's buccal swab. In this case, all she did was some sort of a review that she doesn't make clear from her testimony was a redoing of the tests.
Let me ask this. If we go through the same analysis on mandatory disclosure that we were talking about in the other case, in other words, a product prepared at the request of the prosecutor, is it necessary for us to reach those other issues? You had two other issues, the Sean John issue and then the due process issue.
If it depends on how this court sees its the remedy for the first
Okay.
discovery
Because
issue.
the disclosure in this case was a little bit more developed than it was in some of the other cases. I understood here that the judge denied a subpoena, but said you could bring it back under certain circumstances.
Correct.
And then there wasn't a subsequent subpoena requested. Is that right?
Correct.
So your argument is then the 240-21C is a separate analysis from what applies under the subpoena section of 240-20.
Correct.
Right.
And with respect to the subpoena, what the court was asking counsel to do was meet an extraordinary or a much greater.
Yeah, the court, with respect to the court, it seemed that it conflated the Brady obligations with other obligations, and she set it out in her decision. But there's no reason for us to go into that at any great length, just that there was a subpoena process here that subsequently was tried.
So just to be clear, and I want to make sure I understand you, are you saying that if we were to agree that you were entitled to the discovery and reverse and send it back for a new trial, then we don't need to get to the Confrontation Clause issue, but if we only use the Degata remedy, then we do need to get to the Confrontation Clause issue? Is that what you're saying?
Partly, yes. I would urge the court not, even if it only found that the discovery should have been turned over, I would urge the court to still reverse and grant a new trial. The reason this is different from Degata is that in this case, counsel's motion was made pre-trial, and in Degata, that was I believe, 3:30 motion after a verdict had already been rendered. And therefore, the remedy should be different.
But here
I would
we have a
argue that
verdict
here,
also, right?
I'm sorry.
Here we have a verdict also.
We have a verdict, but the motion for the discovery was made pre-trial.
330 is
and
just not applicable here.
Granted, but my argument is that the defendant should be returned to the position he was pre-trial and then, given the discovery and be able to use it in
If we
whatever.
reversed on confrontation grounds and sent it back for a new trial, you would apply the new discovery rule, right? You would get the
Yes,
discovery. Yeah.
that's correct.
So that would solve the problem?
That would.
Yes. Okay.
Thank you, counsel.
Thank you.
Counsel?
I just want to speak briefly on the remedy because I didn't speak on that in the prior case. So the remedy is laid out in Degata. If this court does reverse, the case should be sent back so that they can make a showing that this is going to create some reasonable probability of a more favorable result upon retrial. Just sending it back for a new trial without knowing that, the trial could end up as, they don't even use the raw data at all. So it's really could result in an unjustified windfall.
So basically, order the discovery to be turned over and then let them figure out whether they want to bring a 440 motion.
Basically, I don't think it matters whether it's, the 330-30 and the GOT or 440.
We're
right.
past 330. We're
Right.
post-judgment
Right,
of conviction.
That's their distinction. I was just saying that distinction I don't think matters.
But counsel, do you disagree that if the court finds that there is indeed a confrontation, defendant's confrontation rights were violated, that we need not answer this question because under the new, as Judge Garcia has pointed out, under the new discovery statute, they will have the opportunity to request that raw data, and you have to turn it over, right?
That sounds like the way it would go. Yeah, if this court reversed on the confrontation error.
Counsel, I'm sorry. You finish answering. I'm sorry. I didn't mean to interrupt.
No, just briefly. But what I really find ironic though about both these cases is that we're dealing with confrontation, and yet they had experts before them that were involved in the actual editing process, the most important stage, and yet they asked nothing about that. They didn't ask about the allele calls. They didn't ask about the edits.
Well, this case took place before Sean John Ray was
correct.
decided.
This is a pre-Sean John decision.
So if we were to reverse, it goes back under, you're not suggesting that if we find a confrontation clause violation here, there's a harmless error way out of this for you, right?
Oh, no, we make a harmless error argument because it was
It's
based...
the only evidence in the case, right? The DNA evidence? What would the harmless error analysis be?
Well, being that she worked on the crime scene sample, that was the first link in the chain that linked the defendant to this crime. She was
That was
listed as the analyst.
Austin, right?
Excuse
I
me?
mean, that was Austin, wasn't it? I mean, Austin was a cold hit.
Correct.
Then
Well-
confirmed by a swab, a known sample later, and that didn't save the verdict in Austin, right?
Well, I mean, the people in Austin didn't rely upon the cold hit. They relied upon the later testing. So
That
here you did
seems-
have the cold hit.
They did, but I think it's clear from this record that as testimony, you relied on the known sample for the link.
Well, that, as Your Honor, I believe, noted in your dissent in Austin, that's really just redundant or
So I
duplicative.
believed
I
in Austin.
don't remember the words you used, but that's basically what you were going for. It all started with that crime scene sample. That's what initially linked him to this crime. So this is a classic, I think, cold hit case, and that's why we submit that any error would be harmless.
But I think that, again, the distinction that was drawn in Austin, and this was discussed in those two opinions, was there was a cold hit in Austin, same type of cold hit that happened here. It was a crime scene DNA developed, put into the system, it hits. In Austin, they didn't do the match in a way that there was no foundation laid for it, linking the crime scene sample to the database sample. And as I read this record, that's the same thing that happened here. I mean, while there might have been a little more discussion that there was some type of hit in a database system, there was no scientific testimony saying this was a known sample of the defendant and the foundation for that in this database that we then compared to. So there was no independent analysis, as I read the transcript, and correct me if I'm wrong, of that cold hit, that's...
You're talking about this case now, Judge?
Yeah.
Independent
And I think it's the
analysis.
same as Austin in that way, it seems.
Well, I mean, in Austin, but still in Austin, they didn't use that. They used the next round of testing. So here, we had substantive evidence of that cold
But
hit
I
presented.
thought that was only admitted to show how they
Right.
why they went after,
You're talking about this case now?
in this case,
Okay.
this defendant, not for, and that the foundation wasn't laid to actually use it to compare.
In the Sean John sense of linking this defendant to this crime, it was the swab, the known sample
Right.
that was used.
Well, I don't think there was any limiting language at trial saying this isn't being admitted for its truth. It was admitted as just for what it was, for its truth. Now, if your question is about the state DNA database hit, I mean, is that where you're going with that in terms of
Well,
the
that's
admissibility?
the cold hit, right? The cold hit is the database hit,
Right.
isn't it? So it seems to me there was no independent comparison with a proper foundation. And in Austin, the problem they had was they didn't bring an analyst down who could authenticate essentially the sample that was in the database, as I recall, for whatever reasons, objections by the defendant or logistical problems. So in this case, I think they talk about the fact that the three things match, but the actual comparison that's done linking this defendant to the crime scene is done between the crime scene DNA profile and the swab profile, the known sample they took after the arrest.
But also a significant difference is that this court found in Austin that the analyst who testified had basically nothing to do with anything. Even the trial court referred to the analyst not as an analyst, but as a parrot. He was just parroting the testimony of, or rather just parroting the results that were, come to by other analysts. So I think that's a very significant difference here. And just to touch upon the subpoena in Velez, the trial court made a very clear ruling, which they didn't comply with. All the trial court wanted was some type of affidavit from an expert showing that, you can do something with this that might go somewhere. They had the FB reports at that time. They could have had an expert review those FB reports and perhaps substantially, provide some substantiation for this claim that you can do something with this raw data, that there's not enough in these FB reports to really analyze everything. And they didn't do that. And that also goes to the right to present a defense claim. Again, they didn't cross-examine them about any of this. There's no indication they sought an expert out. So, that I think really undermines the entire premise of their claim, that they needed this raw data to really present a defense. They had quite a bit in front of them already upon which they could have built a defense, and they didn't do anything. And this court ruled in Colavito that a calculated lack of initiative should not be rewarded. That's what you have in this case, a calculated lack of initiative. It's just to Is my time?
No, sir.
Oh, I'm
Continue.
sorry. Just to touch a little bit on the OCME and the control aspect of all this. Because in Velez, they say something in their reply brief that just isn't true. They basically try to make the OCME out to be sort of like our hand puppet. Like when we say jump, they say how high. And that's just simply not the case. I can give numerous examples to this court of testing that the OCME has refused to do for us. For example, they refuse to test shell casings and cartridges in most cases. No testing of vomit or excrement. No testing of swabs from automobiles used in
In the
crime.
record?
It's not in the record. It's based upon my account. We didn't have a chance to elaborate on this in our brief because they brought this up in their reply brief. So I'm just, but no, it's not in the actual appendix or anything like that. I just like to provide some examples to the court to show that the OCME's discretion doesn't mean that they're under our control or that we have control of every single document that they have.
No,
in their
I don't, I think that's a fair, it's a fair rhetorical statement to make. There's nothing unfair about what you're saying. But the problem is whether or not they're producing a document at your request for your use in trial. And if they're produced, and also to assist them in their examination of trial. So that's, and how we view that, really, I think goes to the mandatory disclosure question. I'm not saying that you control OCME all the way. I wouldn't.
Right, and
I don't think that's correct.
Right, and that's what this
But that
court-
doesn't, it still doesn't mean you don't have to disclose, and that they don't have to disclose certain things. And
mean,
that's what I'm talking about.
I'm just saying, as a practical matter, even if you go with Your Honor's argument, you call it mandatory, if an outside agency, not a law enforcement agency, has something, and we say, please give it to us, and they say, sorry, can't help you. We have too many other cases. This is going to require an enormous, it's going to impose an enormous burden on us to generate this data. It's going to take a month in every case. Where does this mandatory disclosure leave us then if we simply cannot get it? We can't break into their offices and take the raw data. It's just not something we have access to.
Is that still the case?
No. Now there's some sort of computer portal where you can get this
So if we
information.
reversed, and under the new statute they have access, this would not take a month to
No,
produce,
no,
correct?
I don't know the exact time frame it takes, but it's not a month anymore. Over the years, it started going down. If you see, decisions that came out after this case, but that doesn't take away from the fact that at the time these cases were decided, this was the response they
In
gave
other words,
us.
somehow, if something is mandatory and discoverable and they're ordered to produce it, you find a way.
They found a way. I don't know if the technology existed or the computer code was written to. I have no idea how this portal works. I don't know why it couldn't be implemented back then, but it wasn't.
But in any event, you concede now that the people do not have an argument that it's unduly burdensome, because they can do this now in a very short time frame.
Yeah.
And they will,
I don't know
because
what the time frame is, but yeah, no. The burden argument doesn't seem to apply anymore.
Thank you,
And I see my
counsel.
time is up. I ask you the lower court's decision. Thank you.
Thank you. Counsel?
Just briefly on the issue of undue burden. First of all, it was mandatory that this be produced, and the people made no showing that this was so burdensome, as in the case it cited Sackett, that the OCME would not have responded. And critically, the people did not ask. They admit that in their brief. They admit they didn't seek the data. Therefore, it's unreasonable to argue that OCME wouldn't have produced it. Further, in response to the subpoena, the OCME did not argue that it was unduly burdensome to produce it. The OCME argued that defense counsel didn't establish that it was both relevant and exculpatory. And going to the respondent's claim that there was a calculated lack of follow-up on the subpoena, the reason counsel could not have followed up on the subpoena is because he required the raw data in order to show relevancy and exculpatory, which is why there's a discovery statute, so that in discovering material that is discoverable, counsel does not have to make these showings.
Counsel, I just want to make
I'm
sure
sorry.
I understand. In addition to, with the raw data, if you have your expert looking and making conclusions about whether or not OCME's analysis is correct or has some errors or has some concerns, your expert could have, or the defendant's expert could have also run it themselves, that expert could have done it themselves?
I think there was some...
And made decisions about what to edit or not, or that is not what the defense was seeking to do with an expert and the raw data?
Yes, if the expert was provided with the raw data, the expert could run their own test, right? And decide not only whether or not the tables provided by the people were correct, but just generally making an independent assessment. In terms of harmless error, I would just say that even if there were only evidence of the hit on the state database, that doesn't compare with the power of the criminalist testimony that she took the oral swab from the defendant. She found that the DNA profile was the same, and that it would appear only in 1 in 6.8 trillion people, or I don't remember how many Earths. So clearly, this was not harmless error, and I would ask the court to reverse. Thank you.
Thank you, counsel.